Hey there, my name is Johnny and welcome to the podcast. We're here to talk about all things law, but with a particular focus on legal clerkships and legal experiences. I've got Diana here and I might as well let her introduce herself. Diana, give us a quick elevator pitch.
Sure. Well, kia ora koutou katoa, everyone. My name is Diana Chill, and I'm a Law with Honours and Art student at the University of Auckland in New Zealand, with majors in economics and French. I'm someone who's guided by three main values, which are learning, advocacy, and justice. I love learning about new things so I can better understand and challenge existing things, and maybe even build better things in their place. And for that reason, I've immersed myself into a range of different legal experiences, including work experiences. So I've worked at New Zealand-based commercial law firms and barristers' chambers, as well as in Crown law and in academia. And while I'm not working during my time at university, I'm also a king mooter. So Johnny and I actually met, 4 years ago at the 2015 Sydney Mini, which was a debating tournament, but most recently last year at the Australian National Champs for mooting. So that's a little bit about me.
Great. Well, I mean, you've got a lot of experience there and I can see like this progression from debating to mooting.
Mm-hmm.
Could you tell us a bit about your experience at Russell McVeigh? I know that that's one of the big law firms in New Zealand, and you mentioned that you did clerk there.
Yes. So you're right, Johnny. Russell McVeigh is, I think, one of the top in our top tier of commercial law firms in New Zealand. I worked in the litigation team under Polly Pope, who's one of the partners there. And that was my first legal experience. I didn't have very many things to compare it to then. Many of my friends at the time were considering jobs in like professional services industry, or even like the consulting industry. And so for me, what I really loved about working at Russell McVeigh was just being surrounded by people who had chosen law as a career, and being surrounded by people who in that respect were more like me. I got involved in a range of work there, including mostly commercial law matters, but also some pro bono work as well. So the clerks over that summer were involved with fundraising for particular how would you describe it, like social organizations, charities, and so that was really fun. And I also got to learn about the practice areas that Russell McVeigh does work in. So for someone who was just, I think at that point, finding my feet at law school, that was a really valuable experience, just to show me what practicing law might look like in the real world.
You mentioned that you didn't really have any legal experience prior to Russell McVeigh. How did you sort of convince a law firm that you would be a good clerk, or that you were a suitable clerk, given that you didn't have prior legal experience? What did you sort of talk about during your application and your interviews?
Mm-hmm, mm-hmm. So I'll talk about my application first, I guess. So for me, and feel free, Johnny, because I know you've got a lot of application experience as well. So I mean, feel free to jump in. For me in particular, what I enjoy doing, what I tend to do with my cover letters, is I have divided the cover letter into three main paragraphs. So the structure that my paragraphs follow are usually, firstly, why should the firm pick me? Second, why have I picked this industry? So why am I interested in law? And finally, why am I interested in this firm in particular? And I think in my cover letter, while I could not point to any experiences before that I had in the legal profession, I was able to point to experiences that I'd done at university that could demonstrate to them how I portray the skills that they were looking for. So for example, in that first paragraph, like why should this firm pick me, I could talk, I might, look at their website and say, well, I see they're looking for someone who's good at effective communication and good at teamwork. how do I demonstrate that? Well, I can point to some of my mooting experience, for example. So that's something that involves teamwork when you're working with peers or even in groups for international competitions. And of course, it involves public speaking, critical thinking, and how to form an inquiry and then do legal research to get you to a solution. So it was able to bring those experiences into my cover letter, and also then in my subsequent interview that demonstrated to them that while I hadn't worked in the legal profession before, I still had a lot of potential, and these were the sorts of things I was doing at uni in order to build up my potential and build up my skill set.
Sure. I feel like there's a good parallel there between your mooting experience and the ending up at the litigation department at Russell McVeigh. In my head, at least, I think prior to working extensively in any area, mooting is probably quite a good simulation of what it's like to work in a litigation department. Do you think there are any major differences or similarities between what you do in a moot versus what happens in a litigation? Maybe starting with any similarities that do exist and also highlighting any differences that are there.
Yes, so a major difference, I guess, is at least for those graduates entering into commercial law firms, I suspect that an opportunity to appear in court isn't so forthcoming. Like, we wouldn't be able to expect a recent graduate or a junior solicitor to junior in a case before court within maybe the first 2 years of them graduating. And saying that means mooting while dealing with fictional fact scenarios is an very early exposure for people to experience what talking and making submissions in front of a judge might look like and answering their concerns and questions. Another difference that I've heard, because, I'm not practicing yet, I haven't, appeared in a real case yet, is that I hear that in real life, judges will ask fewer questions in an actual hearing than they would, say, in a moot environment. And that's to be expected, because the way you differentiate good mooters from the best is the way they deal with questions and how they answer them, sometimes on the spot, most of the time having prepared answers to anticipated questions. In terms of similarity, though, I suspect that the formalities of mooting are similar to that in real life hearings, although I will qualify this by saying the majority of hearings, I think in the real world, are trials and directed at a judge only or maybe to a jury. And so in that case, mooting, because it's always appealing a question, is not exactly like a perfect resemblance of that. But in saying that, still is a fantastic opportunity to develop skills that are necessary to, thrive in a courtroom later on in a graduate's career.
Sure. I'm in broad agreement here. It sounds like mooting is a bit of a baby version of the real litigation work, right? It sounds like there are less factors of complexity, because I feel like as soon as you add a jury, there's an element that requires you to then simplify the language you're using. You're then not necessarily communicating with a judge who works in the same industry as you, but you're also communicating with lay people, and there are rules around that. It does sound, though, I think you raised an interesting point about dealing with questions in moots, because I think I'm in full agreement there. When you look at an actual trial in real life, it's very much, they're trying to get to the bottom of something. So it's very much, judge asks a very pointed question about submissions that they often broadly agree with, and they're often clarifying things. Whereas I know that in a moot, something that a lot of people don't know early on is that just because you're getting questions doesn't mean you're doing anything wrong.
Yeah.
Arguably, if you're getting a lot of questions that are difficult, it's probably because you're doing quite well and they're trying to poke holes in your argument to see how you're doing. And I think that's something like a lot of people just need to be aware of early on, because they get derailed often by the fact that they think they might be getting the law wrong, which is why they're getting so many questions.
Yes, for sure. I remember in my third year of mooting, I heard that in feedback first from a friend or mentor of mine who had judged me in a preliminary round in a competition. And she said, you should embrace questions. You should learn to take them as areas of concern that the judge has. And because they're putting that question to you, they have some degree of confidence in your ability to assist them as an advocate and as counsel. And so for sure, like there is that misconception, like very, very common in mooting. And, you know, people should learn to engage in those sorts of difficult discussions more, I think.
I mean, speaking from the other side of that, I've had the opportunity to judge a couple of moots. To agree with you on that point, I don't think I've ever asked a hard question of someone that's already struggling, because I feel like as a general rule, you don't want to kick them when they're down. If they're already super nervous and shaking, you don't then pile on a difficult question and just completely break them. So if you're getting a question, it's probably because they don't think you're going to break. But I think to sort of like look at that idea of embracing questions as well, I think it's an idea that's quite relevant in practice as well, because often when you get questions from a judge in real life, it's simply an opportunity to clarify something that might have been mistaken earlier. And it's something I've learned speaking to various partners and barristers that I've had the opportunity to work with, because you would rather have that opportunity to clarify at that point rather than have a misunderstanding occur and then God knows what happens later on. Diana, I know that, taking you back a bit, I know that you mentioned in your cover letter, you both linked firm values to things that you've done. And you also talk about how the third section of your cover letter involves talking about a firm's specific value to you and why you're applying to it. How do you go about this process? Are there certain things that you look for? Are there any resources that you use? And generally speaking, how do you go about the process of gathering that information?
Yeah, so the main thing, well, the very first thing I look for is exactly what the firm is looking for in their candidates or in their clerkships or the people that work there. So usually on their recruitment website, they'll say things like, these are the skills we're looking for. We want someone who is, for example, is curious about the law, is passionate about it, can work in a team, etc., etc. And I find that information useful because not only can I put those exact words in my cover letter or in my CV when I'm describing previous experiences, for example, but also I think it's a good indication of if you yourself think that you're a good fit for that firm. Beyond that though, I usually just look to the firm's website itself, and if I know people who have previous experiences with that firm, might decide to reach out to them and ask them questions about what it was like to work there. And when I'm on the website, the sorts of things I look for are what practice areas does the firm have? Do those practice areas align with the things and the areas of law that I'm interested in? How involved is this firm in the community? What is their pro bono work like? What is the extent that they show off their pro bono work as well, which I think is important in being able to indicate that this firm is engaged in their community. And something that's related to that is also, has that firm, for example, sponsored law competitions or been involved in the law school? Because if they have, then that's going to make me more likely seriously consider them, because you know, law school is such a massive aspect of any law graduate's life. And also things like whether they have a commitment to diversity, whether they have a commitment to making more women partners, for example, all of those things.
Oh, that's interesting. I like that you mentioned using exact words that have come up on a firm's website. I think that it's a really budget way of letting the firm know that you've actually done your research, right? Like, to actually use their words and just essentially let them know, like, I've actually had a look at your website. I think there's a tendency for, maybe it's come out of like law school, right? And like turn it in, calling us out for plagiarism. But we tend to look at things and like immediately we just start rewriting it. Like, yep, you talk about excellence, I'm going to talk about technical, doing your job well or something like that. But it's actually counterproductive, right? I think it's probably easier to just simply use the words that the firm uses to let them know that you have looked at their website and that you're now linking direct things. Like, make it obvious for them, right?
Yeah.
Another really interesting thing, I think, a relatively newer aspect of, I think, job searching for our generation is this sort of commitment to looking at firms' values over things that we care about. Like you mentioned, for example, their commitments to diversity and whether they have, say, gender equity initiatives in place. Are there any other values that you sort of look for in these firms in terms of aligning that with your own personal values?
Mm-hmm. So I mentioned in my elevator pitch that one of my values is learning. I absolutely just love being challenged and continually learning new things because, what's to lose from having your worldview challenged and having the boundaries of your universe expanded. So for me, something that I also look for that aligns with my values in particular are the learning opportunities or the development opportunities that the firm will offer. So for example, I know some firms will have on their website the typical development journey of a graduate, where that graduate can expect to be in 2, 5, 10 years. And perhaps if that firm offers like secondment opportunities, for example, who are the secondment partners, and whether I would be potentially interested in working for those partners. And so that is a key thing that I'm also looking for when I review a firm's website.
Yeah, no, that makes sense, and I think it's something that I personally look at as well. Like I'm big on continued learning. I'm big on the fact that we don't really stop learning just because, say, we finish university or any formal education. One of the things I personally look forward for, and it sort of links together, right, is how innovative a firm is. And we're talking actual genuine innovations, right? Obviously, I'd say pretty much all firms talk about being innovative, but you also look at genuine outputs, like the degree to which they engage with things such as legal tech and emerging other technologies. And to me, these things link together because a firm that is innovative is inherently one that must value learning because they're embracing new concepts, new ideas. And in order to actually even spot these opportunities, to me, it seems like that firm needs to invest in its people and have the best people to look out for these opportunities, who are aware of emerging trends and can spot those opportunities. So I personally look for innovation, and I look for that in areas where you might see firm development. So their insights tab, their news tab, any announcements they make on that. And I mean, more generally, I also just chuck every firm into Google and the Google News tab and see where they're being mentioned in the news. Are they being mentioned in collaborations with innovative partners? Are they getting involved in these sorts of things that show that they're really genuinely progressing an innovative agenda? To sort of take you back, I want to talk about mooting again, though, because it seems like mooting has been a relatively formative experience that has contributed towards, I suppose, the experiences that you've gone after and also what you bring to the table. I know that there are various different levels of listeners out there, and we're looking at newer law students here. Can you give us like a relatively like a mooting 101 spiel here? Like I know some people don't even know what mooting is. So like, what is mooting?
So mooting is the sort of thing that when you're in high school and you think about I want to do law, you think people in courtrooms, you think about people making arguments. Mooting is like, in my opinion, the law student's dream, because who doesn't want to put on a suit and represent, albeit fictional, parties and fictional issues, and debate issues with your peers in front of a judge. So really what it is more specifically though, a simulation of appellate court proceedings. So while competitions in Australasia, like the witness examination, focus on the trial aspect and the first instance hearing, the moot is about exploring issues that have been appealed from a lower court decision. So that is the definition of mooting. And if you want, Johnny, I can like chat to you about like beginners tips and advanced tips, whatever you like.
I reckon that's an interesting distinction to make early on, because I don't think early year law students actually know the difference between appellate and trial hearings, right? And I think it's something that affects their ability to moot as well, because to sort of like put it in layman's terms, right? It's a weird word to use, but trial hearings are pretty much the first time a case is being heard before a court. And I think the main thing that happens when we make that distinction is that in trial hearings, you deal with a lot of evidentiary issues. So whether or not evidence is accepted. So, you know, the very conventional questions of, you know, whether or not evidence is hearsay, like whether or not it's admissible for other reasons, such as, you know, tenancy and coincidence rules or other exclusionary rules, is something that often happens at trial. But then when we talk about appellate hearings, it's pretty much always limited to a question of law. So you're not disputing whether or not certain facts happens, but you're then disputing whether or not those facts produce a result that is in line with certain legal positions. And I feel like it's such a weird area to distinguish on. And I think it's quite difficult to like sort of get that into someone when they haven't had much legal experience as well. So I think you've put it quite concisely there.
And it's certainly not a distinction a lot of people at some point make in law school. I mean, one of our Mooting Society presidents recently just had an epiphany that, you know, why aren't we discussing evidentiary issues in moots? Well, it's because it's an appellate court proceeding. So it's certainly an easy distinction to blur.
I mean, to take a kind of tangent here, though, I think, as a general rule, it seems like we don't really deal with evidentiary issues in law school at all, right? Like, we study disparate. Okay, speaking for the Australian experience, you might want to add a chip in here for New Zealand, but from the Australian university perspective, we study disparate substantial topics. So, like, we talk about, you know, tort law, we talk about criminal law, we talk about equity and trust, etc. But almost, I'd say pretty much we never actually delve into the evidentiary issues that lead up to legal decisions in those cases. So we only talk about the ratio and the legal principles that come out of it. Yet to take it all the way back to the beginning of the podcast here, talking about like that difference between commercial law and practicing law and theory, I feel like a lot of actual real world cases hinge on evidentiary issues, whether or not a certain piece of evidence is accepted, and that could pretty much entirely derail or take a case to victory, depending on whether or not that piece of evidence is accepted. It's just a bit of a tangent there. So to sort of like take you up on that offer before, where, you know, you talked about tips. So to sort of reiterate, I feel like we need to just talk about the fact that you participated in the Philip C Jessup Moot. And for people who are not in mooting circles, I reckon the Jessup Moot is probably arguably the most prestigious moot in the entire world. Like, it's an international moot. You go up against unis everywhere around the world. I know that a lot of American unis participate, etc. And that it's an international comp that's split into like domestic preliminary rounds before then expanding into like a global behemoth of like clashes of like every nation, really. So in that context, like, I think it's pretty hard to actually end up on a Jessup team. From my experience, like, it's a relatively competitive process. And I can tell that you've been doing moots for a while leading up to that point. Can we start with some beginner tips here? Because we sort of like just came from a discussion of what mooting is. So to avoid overwhelming the people that have just found out what mooting is, let's talk about, firstly, what sort of benefits you see to mooting. Like, what have you gained out of mooting?
Okay. So much. I can speak for like probably hours about how the extent to which I've gained from having done mooting for as long and as hard as I have done.
You get
But
kickback from some sort of mooting society? Is this a sales pitch?
I mean, it's a pitch for mooting generally, because I think it's something that if you like have the time to invest in doing it, you absolutely should. And that's because one of the key benefits you get from doing it is developing skills that are helpful in your legal essays, in your like undergraduate degree or even like postgraduate degree, and after that in work. And the sorts of skills I'm talking about are things like legal reasoning, legal research, public speaking is an obvious one, critical thinking, forming an inquiry, and conducting research and an investigation to get to the point, to get to a solution. And then at the end, being able to communicate that in simple language to a judge and answer their questions. And you know, like anything, practice does make perfect, and mooting is just another opportunity for you to really invest in developing those skills, which will help you in the legal profession, which is why like firms and other employers in the legal industry look at mooting or very highly on someone's CV, I think. And sort of related to that, another benefit I found from it is mooting gives you an opportunity to engage intimately with an area of law or a specific legal issue that you previously might not have been able to investigate in depth, or like as in depth in class. And if you're like a massive law nerd like me, and probably like you, Johnny, then it's a fantastic opportunity to build your knowledge in those relatively niche areas, to formulate your own opinions on certain aspects of law. And if you are talking about it, if you find yourself talking about it in an interview, for example, being able to engage your interviewers by chatting about your own opinions formed from the competition. And the last benefit that I'll talk about is also, once you get to a particular level, there are travel opportunities involved, and you just get to make the most amazing friends from competing, for example, in the international moot circuit like I have. The Philip C Jessup Moot was a tremendous opportunity for me to reunite with friends that I had met at previous international moot competitions, and also to make new ones. And I'm in my final year uni now, and I reflect back on what I've done in my legal career at uni, and I think to myself, well, some of my most happy but also most heartbreaking moments have been on the international moot circuit, where I've, broken at competitions, but also not broken at competitions. And it's the friends who I've made, and my teammates and my coaches who have surrounded me to make that experience worthwhile and just so heartening. And the last thing I'll say is, because you're meeting people at this level from all around the world, they've taught me so much about the unifying potential of law, and of international law in particular, of their communities and countries and backgrounds, but also myself and the way that I come into new environments, especially competitive environments, and how I thrive or I don't in those. And so mooting is very close to my heart, which you can probably tell, and it gets you all of those benefits.
Oh, you're dropping some mad value there, Diana. I reckon that's a pretty comprehensive summary of the benefits of mooting. But actually, to clarify one thing before we do go on, you mentioned breaking a couple of times, and I reckon that's pretty specific moot/debate lingo there. And to kind of explain to everyone, when you break at a competition, it means that you've made it past the preliminary rounds into one of the, I expect, final rounds. So usually the quarterfinals or potentially the octo-finals of a competition. So it's really like recognition that you are one of the best mooters / debaters in the particular tournament that you're at. And breaking is considered a massive achievement. So, I mean, that's where the joy comes from, breaking in international comps.
Yeah.
To take you up on a couple of those points, I think it's interesting that you mentioned the development of niche legal knowledge. I think one thing that people might not be aware of in relation to mooting is that you're very rarely given sort of like a stock standard problem. You're always given a problem that's over an area that's quite topical, because inherently the nature of moots is that it needs to be quite balanced. You can't have one side that can railroad the other side with, you know, high court or Supreme Court authority after authority, right? So you're usually looking at an area that's quite unsettled, which means that you're looking at relatively new law. You're looking at topical issues that are currently potentially causing issues in the profession. And to sort of go back to what Diana said, like both before and after that discussion, it's really good interview material, right? Because beyond, you know, you do your subjects at law school and you say you do criminal law, you do commercial law, you do whatever, right? And the topics that you deal with in class are almost always the fundamentals. So you look at the foundations of what that particular legal area is. Maybe if your lecturers are super mean, they might throw in a couple of assessments that deal with contemporary law, but mooting is an opportunity to quite consistently deal with that sort of thing, where you're consistently dealing with evolving law and new issues in the law. To take you up on what you said about like speaking at interviews, though, are there any specific instances that you remember talking about your mooting experience in interviews? And can you tell us a little bit about it?
Sure, yes. A very recent experience actually, when I interviewed for a judge's clerkship position with the New Zealand Supreme Court and Court of Appeal. This relates directly to what you were saying, Johnny, about discussing the contemporary issues that are often presented in mooting problems in interviews in order to demonstrate to the interviewers, in this case, justices of the New Zealand Supreme Court and Court of Appeal, that you were someone, a young person, passionate about the law and also engaged with the cutting edge issues that are being presented at the moment. So I was asked a question about, from when I did contract law, what is a case that I remember from contract law and why do I remember it, or why did I find that case interesting? And what I was able to say was, well, I pointed to one of our 2018 High Court, or Auckland High Court decisions, which was Honeybee Preschools and 127 Hobson Street, which recasted the test for contractual penalties in New Zealand. And I could talk about how in that particular decision, Justice Fata made a very careful consideration of overseas authorities, and I was only able to talk about that case in as much detail as I could because the restatement of contractual penalties was an issue in last year's Australian Nationals final, and before that at our Stout Shield, which is Auckland Law School's most prestigious moot, and I think it's probably come up a few times as well. The key thing, though, in my answer was, it turned out, and I hadn't known this. I was just like casually scrolling through LinkedIn one evening before my interview, and I saw that the Supreme Court had actually recently reaffirmed that very High Court decision, that recasted the test for contractual penalties. And I was like, this is really cool. Like, this is something that I would be able to tie into my answer. And so I did, I thought that was a relatively okay answer to give to that question.
I think it's interesting as well. So to sort of expand on that and take you back as well, you mentioned that public speaking was something that you developed through mooting, and it makes sense, right? Like you're standing there on your feet, presenting an argument or a point of view, and you're also having to defend it through questions, as we sort of mentioned before, when judges start poking holes in all your various submissions. I think an underrated element of mooting is the fact that you probably become better, or you come across better at interviews, right? Because if you think about it from a really weird perspective here, interviews are basically just like moots without the law. Like you're presenting your own value and then you're defending it against people who are asking you questions about it. Like, tell me a time you did this. Like, how did you do that? And you mentioned the benefits of mooting. One of the key benefits is just the fact that you're literally doing the thing, right? Like you're literally speaking. And I made a really quick video about this recently, which touches on it, but I think public speaking is one of those things that you actually can't get better unless you physically throw yourself into it. Like I used to read books about public speaking and how there were different tactics that you could use to, for example, briefing techniques that you could use to slow down and become more composed. And I don't know about you, but I remember the first time I did a debating speech. I have that in my mind. I'm like, stay calm, make sure to breathe in, breathe out. But it took me about 30 seconds before like I felt like literal fire in my face. Like I felt like it was so hot. And I don't remember what I was saying, but it was one big ramble for about a minute and a half before I just sat down and I'm like, I don't think I'm ever going to do that again. But, you know, a couple years down the line and through experiences like debating and mooting, I don't know about you, but like I felt that we've both come a long way and just simply become better at that sort of thing, where even if, I mean, literally the other day, I did a video interview for one of the government graduate programs, and you know how the video interviews work. They give you like a minute to prepare and read the question, and then 2 minutes to actually answer it. Well, what I did was I accidentally double-clicked on the next button, and I just skipped the 1 minute, the 1 minute preparation period completely. So you could literally see in the video interview, like the first 2 seconds of that question were just me like, and like just that moment of realization that I didn't have any prep time. I just read the question and went with it. But I don't think I would have been able to do that without, you know, experience in debating and mooting. It teaches you to calm down, to gather your thoughts and be okay with silence. I think that's actually a really underrated part of mooting, like the ability to just stand there, take a question and not rush to just blurt out an answer immediately, but actually gather your thoughts and give a cohesive response.
And it's precisely because of how underrated that exact thing is and how beneficial it is to develop that skill that I think is something that, especially for people who are just beginning out in mooting, should be told more. And the thing I'm saying here is, with anything, it takes time. Like these sorts of things, we can't expect to get better at them overnight. For sure, there are people who, you know, are naturally charismatic, naturally amazing at public speaking and can do that stuff really, really well. But certainly it doesn't mean that if you don't have it already or you're not currently particularly strong at it, you won't ever develop it. Because I remember like my very first moot ever, I didn't even make it into the next round. Like I was knocked out of prelims, and I'm pretty sure my judges thought that I was like I just treated it like a debate essentially. I didn't you know, refer to any authorities. I was speaking way too fast and treating questions like they were a threat to shut down in a point of information. But then since then, I've you know, stuck to it, and I've you know, competed in internal competitions and national competitions and international competitions, and so it's just, you just got to stick to it. Like if it's a skill you want to develop, there's no magic secret. You just got to keep practicing.
Well, look, Diana, I think that we've talked a lot about these valuable lessons, and I'm hoping by now, you know, young students listening are like, yes, let's do some mooting. So what are some things that you might want to, what are any tips or advice that you would like to give to anyone thinking about starting out mooting? Like, where would you start? What sort of mindset do you have? What sort of things should you be aware of, etc.?
The first piece of advice I'd give in terms of mindset is that being excellent at mooting takes time and a lot of energy and effort and investment. Some young mooters might, or new mooters might decide to and this is something else I would advise as well, take advantage of all the resources that are available to them. So for example, going to attend your law faculty moot finals, if your law society has a note bank of written submissions or even past videos of finals, to watch those things. But also to keep in mind that the people who you see presenting in what, in your opinion, could be seamless and beautiful performances have put in so much work and countless hours of effort and research and restructuring arguments and arguments with their teammate even to get to that level. So I think the very first thing to do is to have the mindset, it takes time to get good at this, takes time, but if you're passionate about it, then it's the development journey that is almost just as rewarding, is just as rewarding, if not more, than breaking or making it into finals or even the win, if you're lucky enough to get there. The next thing I'll say is the art in mooting is about persuasion. It's an advocacy exercise, and when you're an advocate, your goal is to persuade. And persuasion in mooting in particular comes from pointing the judge or your assessor to what previous judges have said about a particular issue. This was something that came out in feedback of in a senior moot final that I went to go watch a few years ago, and I've noted it in the notes app on my phone ever since, because so many people might begin mooting, for example, from a debating perspective, whereby it's so easy to read a fact scenario and instantly, as a matter of principle, jump to what you think is the right outcome, what is the right, where does the justice of this case lie. And while that exercise, that principled exercise, and thinking about where the justice of this case lies is helpful to an extent, ultimately, the reason it's a law competition and not like a debating competition is because authorities are persuasive, pointing to what previous judges have held, and even the obiter comments are so persuasive to the bench and to the person who is judging you. And too many people forget that, especially just starting out as a young mooter. So those would be like my fundamental tips.
That's interesting. I think to take you up on some of those, I think an interesting thing to note at the outset is just the fact that you noticed some feedback at a senior moot finals, and to sort of tie in with that first point you made about the development journey. From my perspective, at least, one of the biggest tips I can give any young mooter is to take feedback really seriously, right? Like, it's something I feel like we get from debate culture, because I think debate culture is very much like, after every debate, we're like, yes, give me some feedback. What could I improve on? And it's something that's not quite as prevalent in moot culture at times. I feel like at times people are just interested in like, oh, did I win the moot or not? But really, to focus on that development journey, I think it matters a lot less whether or not you win a moot, just because at times it will often just be decided by which side of the case you're on. Like, certain cases are simply weighed in certain ways, but I think the true value of mooting comes from the fact that you're often exposed to people who are better at mooting than you. Sometimes you're like, I mean, some people might not know this, but like in the final rounds of more prestigious moots, you'll often have like senior judicial officers, like literal, justices of courts come in to judge you, and they'll also give you feedback on your performance. But even at the junior level, you're looking at gaining feedback from people who have either mooted a lot more than you, or sometimes junior practitioners who do this sort of thing for a living. Like, I know at my uni, we have barristers come in that often deal with actual advocacy issues in court. So, I mean, my biggest piece of advice is to focus on that feedback. And some tips on feedback as a good tangent to this are to be really specific with your feedback. I think that it's quite tempting to leave the question open to your assessor to just go, oh, how can I improve? And I think that's something that's useful to do at the end when you ask for feedback. But I think it's often a lot more useful to be specific with your feedback. So to look at specific areas you want to develop. For example, use of authority. So you might ask your judge, did I use the authorities appropriately? Did I quote them correctly? Did I draw out their value and significance in relation to the case? Or you might focus on something I think most people need help with at the beginning of their moot journeys, the ability to respond to questions. Did I respond to your questions well? Did I address the thing that you were thinking of when you asked that question? And the more specific you can be, the better the feedback will be, because you've directed the judge's mind to particular instances that they then bring up and then bring back, rather than leaving it open, which again, I think it's tempting because you don't want to restrain their autonomy here. You don't want to, say, oh, I only value your feedback in this particular area. But I think it's the other way around, right? Like, you're showing value for their time by letting them know that there are specific areas that you do want to develop on. So that's feedback more generally. I think a really important point in terms of mindset is that mooters often don't understand that, young law students who haven't mooted often think that mooting is a bit of a legal presentation where you have this perfect script of a legal argument and you deliver it and the judge is blown away and they're like, yes, you've won the case. Counsel, approach, you've won the case. But I think the reality is that young mooters need to understand that it's a bit of a conversation. It's sort of like an exploratory journey. The judge is exploring your point of view, and it's a bit like the conversation we have now. Like, there's no way this would have been a good conversation if either you or me had this complete script of what we were going to talk about. Like, yep, I'm going to say this, you're going to say this, I'm going to say this, you're going to say this.
Yeah.
And in looking at that, I think the key to really understanding mooting is that, and this also serves to like understand why young mooters often fear questions, but questions really guide you in that journey because you're having a conversation with someone who wants to be persuaded. Like, that's the reality, right? Like, they want to see your point of view and they're going to have certain questions about that. It's not going to be a perfect presentation because sometimes they might not care about the first 20 things you say, but they do care about a particular sticking point. So having that fluidity and maintaining some degree of flexibility, I think, is really a key to taking someone from, a legal presenter to, a junior mooter who actually understands that you're having a conversation with the judge and you're engaging with both facts, other parties' arguments, and the judge's questions. So,
can I jump in there and say two things on that conversation element, Johnny? That's something that's very near and dear to me in my own mooting experience, because for years my consistent piece of feedback was, you need to sound more conversational. At the moment you're sounding quite robotic, you're quite monotonic. You need to engage the bench more, was the way that feedback was consistently put to me. And I want to say two things, and one of them is probably like a basic tip, and the other is more advanced and something that I found has personally helped me in getting more conversational. And the first of these is, it is important to know what the fundamental cornerstones of your argument are. So these are the stepping stones that that you cannot concede on and are fundamental to winning your case, that anything ancillary to those stepping stones or anything extra are things that you don't need and you don't need to say. And if the judge takes you in a different direction, what knowing the cornerstones are is really important for anchoring yourself back to the internal structure of your argument, so that even when you are derailed, you know what the next step is, based on what you've already established and what you have yet to establish in order to get to the solution that you want to get to. So knowing what those are and knowing what is extra to that is really important. The second thing I will say is, for those who are perhaps more mature in mooting already, and you might have established your own tone or your own style, I will say to experiment around with that style, to experiment around with your tone as well. And a really good thing that I discovered late in my mooting journey to help this is to, in your practices, try and present your legal arguments in a way that you would never in a final. So for example, you might be really enthusiastic and like deliberately overly enthusiastic in your performance. So then that way, if you are quite a naturally measured speaker, then by the time you get to finals, you know where to dial back in on that. But the point of that exercise is to let you know what your voice and what your performance is capable of. And who knows, like maybe being overly exaggerated or pausing for longer than you would feel uncomfortable for, or speaking in a higher pitch or a lower pitch might actually add to the delivery and how persuasive you are. And so what that goes down to is just experiment around with your style and with your tone. Still have a style that is true to who you are and can bring your personality through. But to get to the higher levels requires knowing exactly where the limits are on your style. And if you are able to have a tone that is energetic and engaging, and at the same time can still be conversational, then that is only a good thing.
I reckon we need to have you back for a full session just on mooting techniques. I think there's so much to unpack in that sort of thing, right? Because from my experiences, there's so many elements of your body language that need controlling. Like you sort of mentioned a couple there already, like your pace, your tone, your pitch. And these are all highly intentional things, right? Like the pace at which you speak often needs to be slower. The pitch that you speak at often needs to be lower as well. And then there are elements of nonverbal communication through body language. I don't know about you, but coming from debating, we were very much gestures everywhere. And then at mooting, you grab onto the lectern and you stay there. So, I mean, I'm keen to team up with you again for like a full session just on unpacking mooting technique. But I think those are really good starting points. And I want to focus in on the fact that you need to have an understanding of your cornerstones. And I'm going to tell you a story about where this went wrong, really. It was the very first time I mooted, actually, and it ended very badly. And to cut this story shorter than it should be, the gist of it was that it was a tort law moot, and I was on what would be the plaintiff side, but was the respondent in the appeal. And, you know, basic position on negligence, there had to be, I had to hit all three heads, right? So duty of care, breach of care, standard of care, and causation. I don't know if, I'm assuming it's pretty much the same thing in New Zealand in terms of negligence principles. And what you sort of realize after you do torts, and hopefully, you know, before you do your exam, is that these three things are concurrent elements rather than alternative elements. So you can't just prove one or the other. You have to prove that there was a duty, that it was breached, and that it was caused by the wrongdoing. And like you need to hit all three on the plaintiff side. Yeah, I think I was in like week 4 of torts at that point, and I was doing this moot for the first time, and I had a partner who was a senior mooter, and they actually dropped out, so I was on my own. It was a bit of a bad situation to be in. I got pushed by the judge on the very first element of the case, like whether or not there was a duty of care. And after I think about maybe 6 or 7 minutes, I just, in my head, like I was panicking. I'm like, they're just not buying it. I don't know where to, I don't know, like, I feel like we're all familiar with this feeling. Like you just like, I'm mind blanking. I don't have an answer to like that position. They've stated that they don't believe me. I should probably just let them have it. So I'm like, I was taught the terminology, you know, so like over here, we're like, you know, Your Honor, I won't push any higher on that point. We're happy to concede that point. And I start the next one, and he's like, if you don't have a duty of care, how can you prove a breach of that standard of care? And this is probably an example of, you know, a contradiction to what I said earlier about not kicking someone when they're down. But I was very much down, and I think like there was no actual way to make the law consistent with what I've done. I don't think they enjoyed doing that per se, but literally you can't have a breach after you've conceded duty. So at that point, I pretty much didn't know my cornerstones. I didn't realize that these three things had to be tied together. And so I conceded that first element of duty, and that was it. Like, that was pretty much the end of my moot. I was like, oh, Your Honor, I am indebted to the court. That concludes my submissions. May I please the court? And like, I mean, I think it's a decent example of like understanding your cornerstones and what things you can and can't concede on. To sort of like dive into the advanced tips, I know that you mentioned like we've been dealing with some more basic tips here. So if someone already does have some grounding in mooting, what are some things that take them from a decent mooter to a Jessup mooter?
Yeah, okay. What I was saying before about experimenting around with tone and style, that is, I think, quite up there in terms of the advanced tips that I would give. So what I want to begin with is the idea of mooting as a performance. So yes, while it is a conversation, it is also a very measured, formal conversation. And previous influential coaches of mine have asked me or told me to think about it as a performance. And because it is a performance, that means there must be key strategic decisions that are made of the elements that go into it. So, Johnny, you listed them basically all before: pace, pitch, tone. Pitch is probably the least important, because it's like your pitch. People have a baseline pitch. Like, there's only so much you can do about that. But certainly there are moments in your performance where you might you can afford to be, for example, a little bit emotional, and when you are emotional, you might decide to pause more, you might decide to slow down, you might decide to have the most hand gestures in that part of your performance in order to help with the intention of demonstrating that emotional aspect. On the reverse side, you might decide to like pause at particular moments, or to really like put variation in your tone in other areas when you're trying to emphasize a particular point, or in points that you want to shy attention from the judges away from. And so it's those strategic decisions that you make about your voice, about the way you carry yourself, and also about the way you choose to use hand gestures that are quite advanced tips, I think. With regards to your particular analogy, Johnny, like that's a dramatic example, but also not irredeemable, because what I will say in situations where you do find yourself going down a discussion that you don't want to be having, you can afford to be a bit firmer with the bench at that point. So, for example, with yours, you could say, my apologies, Your Honour, I did not mean to concede on that point. In any case, in the time that I have remaining, perhaps I might best assist you by addressing the second element of negligence. And it's fine to be a little bit firm with the bench like that, because ultimately you are counsel, it's your client, you're there to advocate for them, and while you are an officer of the court, you're less, I guess, like inclined to, well, yeah, it's a balancing act, I think. Like help the judge, also represent your client. You strike that balance in any particular set of circumstances. The final thing that I think I'll say on this is to, once you're at a particular level and you're considering doing the Jessup perhaps, is to tell a story. Keep in mind that while these are fictional parties, they are still parties with their own motivations and their own, stories and incentives. And the most persuasive mooters are not only the people who can engage well with the bench, but are able to, in their engagement, demonstrate to the bench that they have taken a step back from all the case law, all the facts, all the evidence, and thought to themselves, where is the justice of this case? What is the the objectively fair outcome for my client, or it could be for the other side? And how am I able to demonstrate that humanity to the bench by telling that story, but also by making it simple? Some people are intimidated because they think, well, mooting is so, advanced, so sophisticated and complicated. And while that is true, the best mooters are able to portray all of that complexion, all of that, well, I'm not sure if that's the right word, complicity, complexness, complicatedness, all of that mess, that legal mess, in the simplest of terms. And it might seem counterintuitive because, they say, at the beginning, you should start simple and then work your way to get more complicated and difficult. But really, I think the mooting trajectory is a sort of curve whereby you start simple, get more complicated, and then come back down again, because it's only after you've dealt with the peak where you know what the simplest path is after that. Yeah, probably just those for now.
Well, I mean, I feel like we're completely on the same page there. I think that's actually probably the literal biggest misconception that happens in mooting, other than the basic ones we've talked about. But it's the idea that you need to make things complicated. Some of the best advocates I've ever met, including both people I've seen who moot very well, but also actual live practitioners who vary from between barristers to judges. The one piece of advice they've always given is that simplicity is always better than any degree of complexity. That's the word. Wow. But when you dive into the case law on any topical issue, you're invariably going to get swamped with conflicting opinions, different factual matrices. Jesus, vocab's a struggle right now. But the point is, inherently you're dealing with complexity, but the best advocates make that simple. So I think you're perfectly right in saying that it's a bit of a curve. You start out with the most simple version of the message, and I mean, I think I made a video about this as well. It's the idea of putting the conclusion first, right? You want to put the essence of your submission into what I think should be 1 or 2 lines. That's pretty much, it encapsulates your entire position. And this is where questions once again come in, right? It's the idea that you should give the judge a roadmap to everything that you want to say. And it's then up to them to pick that apart. They might say, I agree with this part of your submission, but I have a question, or I have difficulty understanding this part. And that's why you start with that simplicity, right? You start with everything encapsulated in 1 or 2 nice sentences, and then it's up to them to break that down into the complex parts that make up that statement. But once you've dealt with that, you then return back to that nice, simple, pretty much conclusion that you've now established is acceptable to the judge, including what they've asked you. I think simplicity is probably the least understood part of mooting, because it is so inherently complex at times, but simplicity is probably a really good advanced tip. To sort of, I guess, deal with this idea of questions as well, I think the only thing I would add to these advanced tips here is, in terms of answering questions, I think people misunderstand that it's a bit of an inherent skill. I think it's a mixture, right? It's something that you develop, but it's also something that you prepare for. I think this is probably where it helps you with interview skills, right? But the idea behind, I think, mooting often is that you're preempting at least 80% of the questions that get thrown to you. Ideally, you want to preempt 100%, but from experience, you usually get thrown by maybe one or two questions anyway when they realize you can't answer questions. But the idea is that you want to preempt the sorts of the sorts of questions you might get in a particular line of argument. And often this will be useful in terms of thinking of what arguments the other side's going to make. And I think that's something that, lawyers in practice do quite often. They think about what the other side's key arguments are going to be and where, particular factual pieces of evidence or factual key facts that press down on weak points in their case. And in terms of then dealing with that, once again, reverting back to that idea of the fact that mooting is very much about authority. At least I think the starting point to respond to questions often is simply to distinguish cases, right? I think often you get questions on the applicability of case law or the non-applicability of case law at times. And the ability to then distinguish and say, this case is different to the present scenario for these three reasons and therefore should be treated differently in this way is a handy way for you to respond to questions in a meaningful way when it feels like you've often got your back pressed against the wall because they're challenging your key authority. The very last thing I think is important here, and I feel like my tips are at this point like intermediate tips, whereas you've given like the real advanced tips here. I think the last thing to mention here is knowing, once again, I think it's very similar to like understanding your cornerstones, but it's knowing when to give up a certain, to concede. Because I think one of the things that happens from my experience is that judges will often throw in hypothetical things to you. They might ask you, okay, but Mr. Nguyen, if this were to happen, then what? And often, they'll often just be throwing you a red herring, right? Like, if that did change, you would be happy to concede the case. But from experience as an intermediate mooter, I sort of, after that torch case, I had it inbuilt into my head that I was never going to concede anything again because I didn't want to derail my argument like that again. So I'll just stick to my guns. Yet often at times, judges will throw in those red herrings, Mr. Nguyen, if this, then that, then what? And I'll just argue it ferociously. And at the end, they give me feedback like, you could have conceded that without hurting your case. I was just wasting your time, but you took the bait. I think that's it for me, unless you've got anything to add on those things.
And sometimes just quickly on that, you are required to stand for hard lines. And those hard lines are uncomfortable because that's why, the issue is on appeal. It's why we're spending all this time, money, and fictional money and resources to argue this case before a court. And one really good example of a hard line is one of the issues from this year's Jessup problem issue came out last year, which was about the extent to which we value the immunity of our foreign diplomats or even our heads of state and our ministers of foreign affairs against the sanctity of prosecuting war crimes. So in our particular case, a Minister of Foreign Affairs had been charged by the International Criminal Court for war crimes, but they also had state immunity. And the question is, if on one side you're prepared to stand for, we should prosecute these war crimes because they're terrible, they're the highest, the prohibition against war crimes is the highest norm we have in international law. Are you prepared to stand for the potential unfolding of international relations because this person can no longer enjoy immunity? Yes, I'm prepared to stand for that. I say that the war crimes are important, are more important or important enough to warrant that sacrifice. And similarly, on the other side, it's like, are you prepared for these victims to potentially never receive justice because this minister can entrench themselves in power because of their immunity? They have to say, yes, like it's our interest in international relations is worth that or something. And so sometimes you're just in a difficult position, and the art of the mark of a real advocate is your ability to deal with that bad situation. Is the last thing I'll say on that.
100%. I think it's very similar to the experience you might get from debating, but it's often having to stand behind those hard lines that you might not personally agree with, but
Mm.
I think it's something that I can't speak from experience, but I would imagine it's relevant to lawyers, just in the sense that I can't imagine any lawyer would go throughout their entire career and
Oh, yeah.
only represent people that they're entirely principally consistent with. I can
Mm.
imagine you'd probably represent someone who has done or not done something that you do not agree with, but once again, that is the art of the advocate and often the job of the lawyer.
Yeah, and especially for defense counsel, right? It's like you're not there because you necessarily agreed with your person who like could have murdered somebody, but you're there because you believe in fair trial rights. And if representing people accused of these crimes is what it takes to reinforce our fair trial rights, then yeah, that is something that defense counsel stand for.
100%. On that note, I think I've taken enough of your time. So to wrap up, I've got a couple of more fun topics to talk about. Firstly, I know that you're a movie buff rather than a bookworm.
Yes.
What's your favorite movie of all time? Like, to end on a fun note.
Okay, my favorite movie of all time is Call Me by Your Name.
Call Me by Your Name.
Call Me by Your Name. For the life of me, I've forgotten who the director is. I feel so bad about that.
You
But
remember
it stars Timothée Chalamet, and the theme song is Mystery of Love by, I've forgotten their name too, Surian Stevens, I want to say. I love it because it is heartbreakingly beautiful. So that is my favorite film. I'm also a Marvel fan, and my favorite Marvel movies are Ragnarok, go figure, and Doctor Strange.
I mean, you're here sitting here like talking about, oh, I don't remember the director's name and I can't remember this, and I'm like, you must be amazing at trivia. Like, you're just remembering all these details. Like, I don't even know the name of the movie sometimes. I'm like, yeah, it's the one with the guy with the hammer. Oh yeah, that one. Directed by, I don't know, probably Steven Spielberg again.
Johnny, if you think that I'm good at trivia, then then you've got another thing coming. I'm so weak at trivia.
Oh man, law nerds. At least we'll be able to answer like ridiculously specific legal questions. Like every now and then, I see them pop up in trivia, and I'm like, I know that. What does taught mean in French? A simple wrong. I know that. I know that from the moot that I absolutely did not crush. I know. Well, Dee, thank you so much for your time. It's been an absolute honor having Jessupian up here in the podcast and talking about all things mooting and really clerkships here, really. I won't take up too much of your time. Thank you for coming.
Thanks for having me, Johnny. This has been a lot of fun, and I hope people can get something out of this.
I reckon we might gauge interest for a potential mooting seminar where you share like all the fully advanced tips and get people to become pro mooters. Like
yes,
you.
Happy to do that.
All right. Thanks, Diana. All right, family just started cooking in the kitchen, and I'm like, close the kitchen door. We're hearing a lot of dishes rumbling around. So, action back in 3, 2, 1. Actually, wait, no, refresh me. What was the last thing you said just then? I just didn't remember what I was about to say.
You just got to keep practicing.
Oh no, we've lost it. I don't know what was about to come after that.
Well, I was talking about like
You're going straight into the bloopers.
So that is a good question, and I think something that people should. Can you ask that to me again?
Yeah.
you do what you need to do, Johnny. Like you've got more editing experience than I have. So I mean,
I have zero editing experience, so we might be in trouble.